We're excited to hear from Diahanna Vallentine today as she walks us through the importance of estate and legacy planning. We chose today's topic because creating a thorough estate plan can give you the peace of mind about the future and assurance that your loved ones will be well provided for. With that, I'd like to go ahead and introduce Diahanna. Diahanna is the financial program manager specializing in financial help for multiple myeloma and AML patients. As a professional financial advisor and former caregiver of her husband who was diagnosed with multiple myeloma, Diahanna perfectly understands the financial issues facing cancer patients. And with that, I will turn it over to Diahanna.
Hello, everyone. Thank you for joining on this Tuesday. It's beautiful here in Louisville. I hope you all are enjoying a nice fall. First of all, before I do anything, I want to present this disclosure. This is just a very basic overview of estate planning. I am not an attorney, and I'm not providing advice other than highly recommending meeting with your financial advisor, tax professional, and estate attorney to review your options, and there are so many. So with that, let's get started. So the basics of estate planning, and some of these things you're going to recognize throughout this seminar. So by the end of this presentation, I hope you'll be able to have a good understanding of what an estate is and why you need to have one, as well as how to find the right persons to help you plan and implement your estate plan. So we're going to go through what is an estate, who has an estate, what is the purpose of an estate plan, what are the parts of an estate, who controls an estate, consequences of not having an estate plan. Next slide. Who are the key players in an estate plan? This is very important to know. The importance of naming beneficiaries. What if you want to leave your estate or a portion to a charity? Who will handle the donation? And can you be a donor prior to your death and get any benefits from that? What are the benefits to including legacy planning in your estate plan? So these are some of the things we're going to address. Next slide. The key players in an estate plan, you're your estate attorney, and I'll tell you, this needs to be someone who has experience in estates and has been doing it for a while. Your financial advisor, if you have one, they manage your assets. They'll know where all those things are. Your executor, this is a person you're going to name in your will or your trust to manage the distributions of your assets per the will. And this needs to be someone you trust and someone who is able and willing to manage this for you. Your trustee. Now, this is a person who will handle the distribution and management of your trust. There are so many trusts out there. There's not enough time in a day to go over the different types of trusts. This person should be a trusted person or entity. If you have family, friends, someone you trust and who's financially savvy, that might be a good option. If you don't, then you might want to have an entity that is like a trust department with a bank or with a brokerage firm that can handle the trust on your behalf. And then there's a healthcare surrogate or POA. They handles either or both your health and medical affairs in the event you are incapable of doing so, and they are triggered at incapacity. Next slide. So what is the definition of estates? Very simple. An estate is all of the money and property owned by a person, especially at death. This estate also includes your outstanding debt. So it's everything you own and everything you owe at your death. That becomes part of the estate. Next slide. So the importance of estate planning, having a good comprehensive estate plan in place can help you feel more secure about your future as well as your family and confident that your loved ones will be taken care of. An estate plan can help you achieve a variety of goals and objectives, including, and this is not all inclusive, providing for your spouse and children, preserving assets for future generations, supporting your favorite charity, ensuring all of your assets, including those that passed by beneficiary designation, such as life insurance and retirement accounts, will be distributed according to your wishes. It minimizes taxes and expenses and ensures that the individuals you choose can make decisions on your behalf in the event of your incapacity. Next slide. So some of the considerations when you're before establishing an estate. Things you need to think about. I would suggest always getting out a piece of paper and list these things out. You'll be surprised at what we miss, but once we have time to look at it, go back and readdress it, digest it, you may find there's changes need to be made. So the most you can get yourself up front doing yourself is less you're going to pay for your attorney to take care of it. So things you need to be aware of: making sure your heirs can manage their wealth, or getting them the help they need to manage their wealth. That's why I said with a trust entity, a 12th trust department handling that could be a good option versus the person doing it, the beneficiary doing it on their own. Do you have a family member that has special needs for whom you want to provide resources and care? To whom do you want to leave your financial assets or a portion of your assets? Do you want to assign specific assets to specific people, like jewelry or art or things of that nature? Do you need to protect assets from ex-spouses or creditors? You'll be surprised at how often these things are not up. Your wills or trust, your estate plan is not updated. I, in fact, had a client years ago who had a life insurance policy, and they had been married to the then wife at their death for probably 14 years. He forgot to go in and change the beneficiary on his life insurance policy. And I had to sit here and give everything to the ex-spouse, and they did not have children. So it was a really uncomfortable thing, because now the spouse who's been helping him, took care of him through his illness, is pretty much out of a huge, significant portion of his assets. So it's very important, if you have something in place, go back and review it and make sure that it's where you want it to be. Next slide. So are you also concerned about the timing of the distributions to heirs based on ages, second marriage situations, or beneficiaries of different generations? Do you have any potential beneficiaries that have specific needs that you would like to provide for, like maybe someone who is not able to work because of a disability or partial disability, or you have some people that you just have really provided for or cared for in the past, and you want to make sure there's some assets left for them? Those things need to be specified in your trust and in your will, or they will not be distributed the way you want them to do. Do you have a business that will require succession planning? This is really huge. Business and personal can be completely two distinct things because of requirements involved, or maybe you have co-owners. This is something you need to do, because if you don't do that, then maybe that co-owner has a right to that business, and your family may not get the benefit of all the work that you've done to build that business. Next slide. So evaluating your assets is another consideration. This will include everything you own and everything that you owe. Don't forget assets that are jointly owned with you and someone else. Let's say you have a rental house and it's in your name and someone else's, and you have your co-owners. Then you need to make sure, you need to understand that half of the value of that property is now part of your estate. The rest of it belongs to the other person who owns that in your along with you. Also consider your chances of an inheritance, or if you have an interest in any trust. These are also part of your estate. A good idea is to have a spreadsheet of the name and the type of the asset, whether it's property, real property, or undeveloped property, or art, or anything. You need to know the value of those things and who owns it jointly, or if it's in your name only. Also be aware that some people have assets that are outside of their residential state. When you name an executor or trustee or someone who's going to handle these things on your own, you have to be aware that there are state laws, different state laws to manage with the management of estates. And so you may have to employ an attorney in the estate where the other properties or other assets are. Don't forget to include debt. That's huge. You need to know what your actual asset or your value is, or the value is after debt is paid off. Next slide. So understanding the tax ramifications of your assets both now and later, because it can be different. What federal transfer taxes will you have, and how can they affect your estate? They can be very, very substantial depending on how you have everything set up. Understand your federal gift tax opportunities. Understand generation skipping transfer tax. And will you have transfer taxes that may affect your entire estate or a portion of your estate? You need to understand the importance of gift taxes. because there may be things you can set up prior to your death, such as insurance, an insurance policy that can offset the taxes. So you want to sell a particular asset in order to pay for it, which means you may not be leaving that beneficiary as much as you wanted to. Life insurance can really be a big part of your estate planning. Next slide. So there are documents, and some of these you may be very familiar with that you can use to carry out your goals for establishing a really solid estate plan. A will is the most common estate planning tool document. Most people are aware of wills. Unfortunately, many people stop at the will and are unaware of other tools that are available to them. And I would suggest that is why it's very important to work with an estate attorney, because they'll be able to see your particular situation and provide you with resources that are going to help you achieve your goal. The will lets you direct how your assets should be distributed, to who you should manage your assets and to whom is going to manage your assets after your death. That person is usually named an executor. So what is probate? A lot of people, this is one of the most misunderstood terms by most people. A lot of times people say, if I have a will, I don't have to go to probate court. That is so untrue. Whether or not you have a will, your estate can go through a process called probate in probate court. This is a process that manages, settles, and distributes your property according to the terms of your will or intestate law. Intestate is a huge one, and I will explain that in the next slide. But what that probate, when you pass, or someone in your family passed, you might find yourself having to manage this. You need to make sure that you have all the documents, the will, and you're going to present that to the court to say, this person had these assets, this person had this assets, and the will is actually saying where they're going to go. Whether or not you have a will, you're going to have to go to probate and say, this is what's going to manage it. And if they see that there's a lot more involved or there's assets need to be distributed, they're going to tell you you need to distribute assets and, how much is left outside of probate. There's a dollar amount. So next slide. Durable power of attorney. This document allows you to name someone like an agent to handle your financial affairs if you are no longer able to do so, and they are triggered by incapacity. Requirements may vary between financial institutions like bank or your brokerage account. So check with them to find out what documents you'll need to have to file with them. Some require an attorney drafted POA, and others may offer their agent authorizations through their particular organization or company. Next slide. Power of attorney for healthcare. This is a very, very important document. This power of attorney appoints a trusted family member or friend to make decisions about your medical care if you are unable to make them yourself. You may also want to appoint a successor or joint successor in the event the named person is unable to make those decisions or unwilling. Keep in mind it's a very emotional time, especially if it requires very serious decisions about your care. Therefore, it's very important to discuss your desires well in advance when the person or persons you want to name as your healthcare surrogates are available to understand and know where your documents are. They need to be able and willing to make decisions based on your wants, when and if that time comes. And I will share a personal experience. My husband, coincidentally, I am sitting here at the hospital where this actually happened. And this is the first time I've been in this place since that happened in 2012. He had sepsis and he was having a hard time breathing and respiration and everything. They're going to have to put him on life support. And he and I discussed, we had a trust in a place, but there was a lot of changes he needed to make to them. But he never got around to it. I kept saying, honey, we can't wait. We can't wait. We can't wait. These things have to be done. We were actually in the hospital room with him where I had to call the attorney from downtown. Fortunately, he was only a few blocks away. We were able to get nurses in the room to be the witnesses as to what was going on. He was so weak, he could hardly hold the pen to sign. And these documents can be quite lengthy. You may have 10, 15, 20 pages, depending on how complicated your estate is. I had to put my hand on him to steady his hand to help him sign these documents. Within 5 minutes of these things being done, he was put on life support. You do not want to be in that situation. It's emotionally charged. I look back and it's one of the most horrible things I went through, but it's something that can be done in advance so you'll know that these things are taken care of. It's the last thing you need to be worried about. The next slide. So privacy releases, a lot of times when you go to a hospital or a doctor's office, you have to sign these privacy releases. So these documents are offered everywhere you go for your medical providers. It gives them permission for someone on your behalf to access information and documents necessary to represent you in healthcare matters. They may ask for your phone number, if they can leave messages on your voicemail, if they can talk to you about medications, by everything. So many of the healthcare POAs have this included. Make sure you check with your providers to make sure they are completely covered, as some providers have their own privacy waiver. You may have to have two things in place. Make sure that if you have a durable power of attorney, living will, that your providers, all of them, have access to those documents. And again, as well as that person who's going to be handling these things in your behalf. Very important. You can't scramble along around at the last minute and not have a hard time. I have a hard time finding them if this could be a situation. Trust me, things happen when you least expect it. Next slide. So a living will or advanced medical directive, a lot of people are familiar with these, perhaps the most emotionally charged estate planning tools. And I would say one that requires a lot of thought and planning. You want to make sure that the person or persons you name are very aware and willing to make decisions and give instructions to your physician on the types of life-sustaining treatment you do or do not want if you are unable to communicate these decisions on your behalf. My husband and I discussed this even before we were married, 28 years before we end up in a situation like this. So make sure you're on the same page. Next slide. Trust. There are so many types of trust, crits, crats, cruts, charitable remainder, all kinds of trust. And don't just think that you set up a trust and it's the best trust for you. You need to speak with an estate attorney who's very well versed on trust to make sure it is set up correctly for you. Everyone's circumstances and beneficiaries and desires are unique. So again, it's always advisable to make sure you work with an established estate attorney to plan this out with you. You can make changes, of course, down the road if you need to change. Make sure that you understand there are irrevocable trusts. That means once you put those things in place, they cannot be changed. Or there are revocable trusts where you can go back and change them. This can also work with your financial advisor and tax professional, make sure nothing is left undone. All of your professional advisors, tax, financial attorneys can work together to make sure your entire estate plan is in place. While trusts are often used as part of a plan to minimize or eliminate transfer taxes, there are also other reasons unrelated to taxes to establish a trust while you're alive or to create at your death. Next slide. Probate. Again, we talked about this earlier. What is probate? Again, misunderstood by many people. Whether or not you have a will, your estate can go through a process called probate and probate court. This is a process that manages, settles, and distributes your property according to the terms of your will or intestate law. In addition, if there are minors involved, they may have to appoint a guardian over those assets for your benefit of your guardian, of the minor. Next slide. So intestate, this is when you die without a will in place. At this point, your assets are distributed according to the intestate laws of your state, and they vary among states. Generally, and I will say very generally, these laws typically are designed to reflect what most people want to happen, that they're assuming you want to happen, such as caring for immediate members of your family. Warning to you, don't take this as a guarantee that the distribution of your assets will reflect your personal wishes. For instance, if you have a spouse, they may not get all that you intended to them, especially if there's have been a blended marriage or a second family. You may find that the intestate laws may distribute to all heirs versus just your current heirs or by your new family. If you have a blended or a second family, all children could be considered as beneficiaries of your estate. That may or may not may or may not be what you want to actually happen. So can you see the benefits of now estate planning? You'd be surprised. It doesn't matter how big your estate is. These things need to be taken care of prior to your incapacity or prior to your death. Next slide. So the cost, simplicity, and timelines associated with probating in a state varies from state to state. And a lot of times they can be carried out even longer, dragged out even longer, and depending on how many heirs there are to an estate. It is strongly recommended that you speak to an estate attorney in your resident state to help you understand what, if any, challenges your state's probate process may present, especially if you have a large or complicated estate. These steps should be done prior to the establishment of an estate plan. This will help you direct assets accordingly. And there is a organization that we have partnered with. It's called Triage Cancer. These are attorneys, so nonprofit or attorneys. They can help you give you answers or specifically to you. They won't practice law with you, but they can tell you, direct you to resources that can help you understand what a state is and things that you need to do in your state, in your estate, according to the state that you reside in. Next slide. So we tend to forget that when a child turns 18, new laws come into play. They are now considered adults. And so you may have had what to set up things to manage or control. But once children have to have their own documents in place, they are no longer part of your things. They are individuals as adults now. So be aware of those things. You no longer have access to their healthcare details unless you're a power of attorney or unless you're a trusted representative. And all of their healthcare providers will need to know that as well. And you're going to sign off unless they give you permission. You're not going to be able to ask questions as well of their health. Next slide. So I want to talk about legacy planning and part of inside of estate planning. And there's a lot of tools you can use. What I have found in over 25 years, including myself, is you may be able to find ways if there's a charity that you are emotionally tied to, that you want to leave something to that charity, in addition to leaving things to your normal beneficiaries. You might want to talk to an estate planning or financial advisor to make sure to carve out what you want to do. It could be cars, real estate, boats, I mean, all types of things, art. And there's a lot of benefits to leaving some of those things that you can take advantage of some tax write-offs prior to your death. So not understanding the many benefits to giving is one of the most misunderstood challenges to legacy planning. Three very important questions to ask when considering becoming a legacy donor are: when should you plan to give prior to your death and or after your death? What you want to give and to whom you want to give. Proper estate planning will take all of these things in consideration, as well as the tax consequences associated. Legacy planning often provides the opportunity to leave more to a charity than you would otherwise be able to do so. Next slide. So planned giving is it's almost like gift planning or legacy giving. It enables philanthropic individuals to make larger gifts to charitable organizations they would have made from ordinary income, and tax benefits as well. Next slide. So how do the planned gifts or planned legacy planning, how does this work? Some planned gifts provide lifelong income to the donor, that being the person who's still alive who's making these things. While other planned gifts use estate and tax planning to provide for charity and heirs in ways that maximize the gift and or minimize its impact on the donor's estate. Yet others can be simple charitable gifts through a will or a trust. So an unplanned gift is any major gift. So a planned gift, I'm sorry, there are typos here, and I was at the hospital trying to look at these things and must have missed a lot. So planned gifts or any major gift made in a lifetime or at death as part of the donor's overall financial and or estate planning. Next slide. So there are three types of planned gifts. First, there are outright gifts that are given over appreciated assets such as stocks or as a substitute for cash. And second, there are gifts that return income or other financial benefits to the donor in return for the contribution. Third, there are gifts that are donated after the death of the donor. Next slide. So what kind of gifts pay income for life to the donor? Charitable gift annuities These are insurance products. Make fixed payments to the donor starting at either the time of the gift, but those are immediate payment gift annuity, or at a later date, deferred gift annuity. In some organizations, these funds can be pooled together or in income funds. They're commingling the donations, and they pay the beneficiaries through variable spending on the earnings of the fund. They generally operate like a charitable mutual fund. Charitable remainder unit trust and annuity trust are individually managed trusts that pay beneficiaries either a fixed percentage of the trust income or a fixed dollar amount. Now, these things can be very, very, very complicated, and this is why you need an estate attorney as well as financial advisor to help you manage these particular types of donor gifts. Next slide. So there are a lot of tax benefits to giving, and they include a charitable deduction for the full market value of the asset, where the donor will pay no capital gains on the transfer for donated appreciated property like securities or real estate. And for donated life income gifts, the donors receive an income tax deduction for the full fair market value of the assets contributed minus the present value of the income interest retained. If the donor fund their gift with appreciated property, they pay no upfront capital gains tax on the transfer. There are so many tax benefits to giving certain types of gifts, and when you give them is very important. Next slide. So when gifts are transferred at the death of the donor, like a bequest or a beneficiary designation, such as a life insurance policy or retirement account, they do not generate a lifetime income tax deduction for the donor, but they are exempt from estate tax. So you have a life insurance policy, you have a beneficiary name on that life insurance policy, that is, as well as an IRA, such as a pension through your company, your employer, or your individual retirement account, as long as a qualified account. Those things have beneficiary type to them, and they stay outside of a will because your beneficiaries are already named. Next slide. So do you have to be rich to give? No. In fact, a lot of people give maybe monthly or annually to their favorite charity, and it does not have to be cash. You can donate other things like vehicles, art, or other items. Many people would like to donate more to their favorite charity, but are unaware of the opportunities available to them that will allow them to give more and have additional tax benefits. Working with a financial advisor, tax professional, and an estate attorney can help you identify opportunities to give to your favorite charity. HealthTree has many opportunities in which you can participate. Go to healthtree.org or contact us and speak to someone who will be glad to assist you if you're willing to give back to HealthTree. Next slide. So I think that's it a lot, but I tried to make it as simple as possible. There, like I said, Triage Cancer is a great resource for everyone to go to, and they'll be glad to talk to you one-on-one, and they have state-specific resources available to you.
Perfect. Thank you so much, Diana. I know I've learned a lot. Take just a few minutes for questions.
Okay.
That's good. Okay. So our first question says, will can be contested. Is it true that a trust cannot be contested?
Well, trusts are generally are easier to manage. They are not as contested as often as will. Just because a will is contested does not mean it's going to go on it's going to be in favor of the person who's contesting it. That is why, and there's so many ways wills can be drawn up. You can have a simple will that people can get online, download online and fill out. You need to have some wills need to have witnesses, one or two witnesses, and some wills, depending on how complicated your estate is, should be done by an attorney. If you're done by an attorney, they're going to try to make sure it is as tight as possible so that the chances of being contested are slim, especially if that person contested it, to try to prevent that person contesting a will and win. There are situations may pop up where there may be errors that you weren't aware of that may pop up later on after the death of that person. And so, yes, they, at that point, they do have the opportunity to contest a will.
Perfect. Thanks so much. We've got a question about 529s. Can
Mhm.
you speak to 529?
529s are money that's set aside for college funding. Usually 529s have a owner, and a lot of times that's a member of a parent of a child or grandparent of a child, with the child being the beneficiary of that 529 to be able to use for their college expenses. However, 529s can now be used for private schools for primary, secondary schooling. You can change the beneficiary or the beneficiary owner of that 529 plan at any time, but it has to be either paid out at an age, I think 32 or 36, or you need to change the beneficiary on that to maybe another person in the family, maybe a cousin or uncle or even yourself. So 529s can be included in a trust. 529s, because that 529 plan, there may be beneficiaries or children who the 529 was the beneficiary of. Let's say you had Tom, and Tom was the beneficiary of this 529 plan. Tom has now gone to college. There's still money in the 529 plan, and he may now have beneficiaries. If you have things set in the trust now may own the trust at death, and the beneficiary, his beneficiary or his children can now have access to that trust, which is the
Perfect. Thank you.
529 as well.
Perfect. Thank you so much. We got a couple comments. We've got one that says, thank you. You answered a lot of my questions. And then we've got another one just asking if we'll be sending out the presentation slides. Ron, yes, we'll be sending out the presentation slides. I'll also send information about triage cancer so that
Okay.
that's available as well.
Now, I will also have an article follow up this month on this webinar for you all to go and refer to as well.
Perfect. All right. And we'll want to see, let's see. I'm going to read through this question real quick. It says, I have a question that may not necessarily be about estate planning, would like guidance in your opinion. I'm currently caring full time for my mother who is bedbound here in our home. But with my husband's recent diagnosis of multiple myeloma, I'm thinking it may be better to move my mom to a care home so that I can focus on my spouse. Also me returning to work full time.
That is a very complex situation to be in. And looking at trust and assets is very, very important to look at. And the earlier you do that, the better off you are. And I'll say this because if a person becomes very ill, such as your mother, mother-in-law, or your husband, and a person may need to have in-home care, and if they've been on state support like Medicaid, and they may have a home, and there's a 5-year look back if funds were transferred to someone else, family members or someone else, that they can come back now and get funds to reimburse the state for the care from Medicaid. So that is why, again, estate planning is very, very important. If things are set up correctly, there's ways to prevent assets from being taken or used for the reasons you did not want to have used for. Again, life insurance is a big thing. I would really suggest, especially in your situations complicated like that, to sit down and talk to an attorney. Talk to an elder care attorney regarding the mother, and then talk to an attorney with the things with your husband. A lot of times, if a person is ill, my husband, when he had multiple myeloma, we found it's best to go through his assets, to start using his assets prior to using mine, to spend down on his before you got to mine. So there are so many things can be done, and an estate attorney can handle these things, and an elder care attorney can handle these things for you.
Perfect. Got another question that says, can you review the tax advantages of donations to charity from an IRA, especially when you must do an RMD?
Yeah, RMD, and you don't have to do those till age 73 now. It used to be 70 and a half. If you don't need that RMD, it can be transferred or sent to a charity as a donation. There are still taxes that has to be handled because there's no taxes been paid on those assets. Again, talk to your financial advisor or talk to your broker who handles, or your employer benefits department who handles that, because they will be doing the transfers and they will need to make sure the tax documents are set up correctly.
Okay, thank you. I've got one more that says, as I'm dealing with multiple myeloma and my vision loss in both of my eyes, we're looking at the special needs trust. Have you been involved with this?
I have, in fact, been involved with special needs trust. Again, that needs to be set up with an attorney so that in your incapacity, the special needs trust, the assets in there will benefit you for your care. I would, again, talk to an attorney and make sure the assets that's going in there is not assets you need outside of a trust. Everything doesn't necessarily need to be in a trust, because you may need needs before that. When you have things in a trust, there are trustees that have to manage the taxes on it, have to manage how funds are being distributed from the trust, all of that. And so they need to make sure, your estate planner needs to make sure your special needs, what needs to be in that trust, how it's going to be used, the tax ramifications, as well as your assets outside of the trust.
Perfect. And it looks like that's all the questions, the live questions we have. So to be mindful of your time, Diana, today, we'll go ahead and close this out.
Thank
And
you.
thank you so much, Diana. All right. So I just wanted to make everyone aware, as you leave today's session, we would really appreciate you taking the 2 to 3 minutes to fill out a brief survey about your experience during today's event. So please make sure you do that. Here are a few of our upcoming events. On Friday, November 8th, our multiple myeloma group will be hearing about dexamethasone, insights on tapering, dose intensity, and eye health from new research. On Monday, November 11th, our AML group will be hearing about venetoclax, everything you need to know in a roundtable format. Tuesday, November 12th, our myeloma group will be hearing about evidence-based pain relief for multiple myeloma, integrating holistic approaches to manage cancer-related pain. And then Friday, November 15th, we have a podcast that is our 2024 mid-year myeloma review. And so those are just a bunch of our events. Our financial webinar, we are going to start doing a bi-monthly Q&A. So if you had any additional questions today or think of any in the coming weeks, go ahead and get on our website, register for that event, and you can pre-submit questions, or you can come to the webinar with those questions ready to go, and we'll get to as many of those as we possibly can. Before we go, I wanted to highlight the Track My Disease feature in HealthTree Cure Hub. Once you've connected your medical records, the Track My Disease feature becomes gives you the ability to gain one-of-a-kind access to your health information, encompassing lab results, genetic profiles, and treatment histories, offering you invaluable insights into your own medical journey. On the screen, I have the link to sign up for HealthTree Cure Hub, along with the email address for our amazing patient navigators. We're available to help you create an account and connect your records. I'll also include this information on how to enroll in HealthTree Cure Hub in our follow-up email, so look out for that. I'd like to again thank our sponsors, Pfizer, Regeneron, Johnson & Johnson, GSK, Karyopharm, Bristol Myers Squibb, AbbVie, Sanofi, Adaptive, and Genentech. And finally, I just want to say thank you all for helping us build our blood cancer community. I've added my email to the side, so please don't hesitate to reach out if you have any questions about HealthTree or any of our programs. I appreciate all of you and hope to see you again soon at one of our other events.